Yes, Ms Gray.
Good afternoon, sir. Good afternoon, everyone. I'd like to start by explaining, for the benefit of those whom I haven't met and who may not be familiar with my role, that I'm speaking today on behalf of the Department of Health and Social Care, or the DHSC, its predecessor bodies and the relevant bodies or organisations which the department was responsible for over the years being considered by the inquiry. These bodies included the Medicines and Healthcare Products Regulatory Agency, the MHRA, the National Institute for Biological Standards Control, or NIBS, Public Health England, or PHE, and the Blood Products Laboratory, or the Bioproducts Laboratory, BPL, for the period that it was state-owned. But instructions in relation to those bodies corporate now come from the current body or organisation, such as the UK HSA, which has replaced PHE. Now, these are the core participants recognised by the inquiry. The legal team that I'm part of has supported the individual witnesses who were employed by any of those bodies, both ministers and civil servants, past and present, throughout the inquiry. But former employees and ministers, i.e. the individual witnesses, aren't core participants and haven't been treated as such throughout the inquiry. So consistently with this, my team and I don't speak, whether in the written submissions or today, on behalf of the individual witnesses who were supported by the DHSC legal team when they gave evidence. I'd like to start, if I may, sir, by just making a few observations on the evidence that was heard throughout the course of this inquiry and about the importance of this inquiry. The inquiry's review of over 50 years of National Health Service history of treating those who suffer from illness or injury requiring treatment with blood products or receive blood transfusions leading to infection has been important and salutary. In its work, the inquiry has given a powerful voice to the patients who are harmed by those treatments and to their families and loved ones. We have acknowledged in our written submissions filed on behalf of the Department of Health and Social Care that we as the DHSC cannot do justice to the powerful accounts that the inquiry has heard over the 4 years and more in which it's gathered evidence. We wish to start again by recognising this suffering and loss. We know that the evidence heard includes harrowing accounts of the physical suffering and psychological injuries suffered by those harmed by infected blood or blood products. The infected and their families and carers, and now the submissions filed on behalf of the infected and affected, or by some directly, have spoken of the challenges in securing necessary treatment and counselling or other forms of support. Witnesses have spoken of the damage and sense of betrayal caused by the loss of trust in clinicians, the medical system and the NHS, and the wider government system that shapes and directs the NHS. Many have told the inquiry of their severe financial hardship and of the loss of dignity and self-respect involved in making applications for support payments, especially those which were means-tested. Campaigners have told the inquiry of the long and until 2017 fruitless campaign for a UK-wide public inquiry and their frustration and distress when lengthy and detailed arguments were met with standard responses that were felt to repeat inaccurate or simplistic explanations or did not answer the questions raised. The call for an inquiry fell on deaf ears, compounding distress in a way that has ultimately been damaging for everyone concerned, whether, first and foremost, the infected and affected whose questions went unanswered, but also those who ultimately were called to give evidence to the inquiry many years after the events in question. Now, we're not trying to repeat the evidence of the infected and the affected, which speaks for itself. But the Department of Health and Social Care began its written closing submissions by acknowledging the force of that evidence and by stating clearly to those who gave it that they have been listened to and heard, and we wish to do so again. Can I come then to the department's position in this inquiry and today? The department, the current department, which as I explained we represent, together with the agencies that I listed at the beginning of these comments, does not have and has not had throughout this inquiry a case to put or a set of views to press on the inquiry. DHSC ministers and the wider government will in due course react to the inquiry's findings and recommendations, but it has not wished to preempt that process by offering opinions now. Yesterday, the inquiry heard submissions made by Mr. Snowdon, King's Counsel, who, with his characteristic eloquence, criticised that approach, contrasting it with, say, the approach of the NHSBT. It was submitted that the department should have set out, in its submissions, a corporate case on what had gone wrong, and that the absence of such a case or evidence of learning represented a lack of candour or good faith on the part of the department. He suggested that I should today, or perhaps he suggested in closing within 3 weeks, set out the department's response, in all but name a case, on a number of issues, whether detailed ones such as the date at which government knew that NANB, non-A, non-B hepatitis, could have serious consequences, or a response to the more general challenge that he made: what does the government accept happened that should not have happened? Let's have the detail. With the greatest of respect, there is not one model of how to participate in or how to respond to an inquiry. And as a result, I'm not going to offer answers to the 6 or so questions he challenged me to respond to. The submissions that you heard, sir, yesterday assume that it is a requirement on the Department of Health and Social Care, ministers and officials, to assess the detailed evidence regarding more than 40 or 50 years of NHS and government actions that the inquiry has heard over the course of 4 years or so, and to make its own assessment of it, and then to present a concluded case or position on this. Even leaving aside the complexity of such a process, it is worth thinking about the implications of this demand, we would suggest. Such a stance would, no doubt, have involved accepting some, perhaps many, of the points that have been made so forcefully on behalf of the infected and affected about the history of those events. We acknowledge that when that happened, that would presumably have been welcome. But logically, it might also have involved rejecting other points, explaining why. We anticipate that that would have been a process that would have stoked disappointment, distrust, and confrontation. It seemed to the department fairer to wait for the inquiry's conclusions than to rush into forming our own. Now, this inquiry, sir, is not in a position of having to rule on the cases or positions of any core participant, including that of the Department of Health. It has the resources and the expertise to chart its own path and to reach its own conclusions. We have tried to assist the inquiry to draw on the information held by the department, that is, both documents and people, as the inquiry has requested. But we're not presenting a case based on the proposition that we can add further insights to the evidence that the inquiry has already heard, or by adding our own conclusions to the ones that the inquiry has heard from witnesses. The DHSC and the witnesses associated with it have very actively engaged with this inquiry, but the DHSC does not seek to urge particular conclusions on the inquiry in its closing submissions. That does not reflect a lack of self-reflection. It reflects the acceptance that it is uniquely your role to make those findings. So we do not believe that there is any requirement, whether in the inquiry rules or elsewhere, to undertake the process that Mr. Snowdon has criticised the DHSC for failing to undertake. That is, for failing to set out, across the huge sweep of the issues which this inquiry has considered, the detailed matters that DHSC accepts should not have happened, or the failings that it does accept. In many contexts, it would be commonplace to set up an expert body, such as this inquiry, to resource it and to support it to the best of our ability, and then to await the results, without further engagement or commentary on the conclusions that it's contended it should reach. Mr. Snowdon does not criticise, as I understand it, the efforts made to engage with the inquiry and to support witnesses throughout the inquiry. The only real difference is that we have filed closing submissions. Now, we might, of course, have remained silent and filed no submissions, but we took the view that it might be of assistance to the inquiry if we tried to draw together the threads of the evidence given by, in particular, those we have represented, this being the evidence that we have the best knowledge of. We hoped that the submissions might assist the inquiry by gathering together the threads of evidence and the perspectives of those who were involved at the time, especially when some of them could not be heard directly as they were no longer available to give evidence. It was our view that the exercise should also be attempted out of fairness to those involved at the time, particularly those acting for the department or departmental bodies. We also hoped that that exercise might assist the inquiry in reaching conclusions that reflected the state of knowledge, as it were, at the relevant time. However, what we tried to do was to be clear and explicit about the basis of our submissions. We also, as part of that process, aimed to set out key material from those sources, that is, predominantly from the witnesses that we represented, as I've just explained, fairly and even-handedly. We also tried to make suggestions about issues for consideration by the inquiry when we thought they were raised by the evidence, rather than to suggest answers or to draw conclusions. For example, on the subject or in relation to even-handedness, we set out the evidence of Mr. Burnham in his witness statement of the resistance he encountered to changing the line, when he said, "During all of my time as Secretary of State, I got the strong impression that the department did not want the position agreed by my predecessor to be in any way revisited. This much is evident in the advice not to meet protesters and the preparation of strong defensive lines for meeting with the MPs, but it was also clear in my interactions with civil servants." That was from his witness statement set out in our submissions. We set out the evidence of Mr. Hunt, that it was ultimately his position that an inquiry should have been established decades earlier. The question thus was how it could have been established by the establishment that nothing wrong was done, and that the line was then religiously stuck to by government after government, as well as Mr. Hunt's reflection that this was the kind of groupthink that was in the government that said, this scandal happened because, good people were trying to do their best, something terrible happened, it wasn't anyone individual's fault, and therefore when it comes to compensation, the matter is closed, set out in our submissions. We also reminded the inquiry, and it's obvious I'm taking a few examples, sir, but we reminded the inquiry, if that was needed, of the evidence of Dr. Walford, when she expressed the concern that the recommendations made by the UKHCDO in May 1983 on the subject of AIDS, of course, were weak because they were advisory rather than mandatory. She felt that a great deal of account would have been taken of them by haemophilia centres, but her personal view was that the most problematic issue was the position of those patients who were at times treated outside of haemophilia centres. We also noted her agreement that no one in the department applied their minds to a more nuanced programme of risk mitigation that had been suggested by risk mitigation that had been suggested by Dr. Galbraith, such as restricting home treatment, limiting surgery, and keeping available NHS products for life-threatening surgery, those sets of steps being put to her by CTI. These are just a few examples of the careful consideration that we tried to give to ensure that the evidence summaries that we put in our closing submissions were full and not partial. Now, we've been criticised, sir, for a lack of candour. With respect, we would say that it is not a failure of candour to say that the department does not have a case or a position to urge on the inquiry when that reflects its position. It's not a failure of candour to set that fact out openly in submissions that are available to CPs and to the public and which will be fact-checked by the inquiry. Equally, we would respectfully submit that it is proper to attempt a summary of the perspectives of those involved at the time. Again, I say, focusing on those whom we represented. In their many aspects and variations, there was no shortage of perspectives in the summaries that we drew together, and we were clear about what we were attempting to do. Quite some number in the evidence of individual departmental witnesses were self-critical or accepting that things could and perhaps should have been done differently by the department. And that was reflected in the submissions that we made. But we recognise, sir, and have recognised throughout, that the task of putting those reflections together with all the other evidence that you've heard is yours as chair of the inquiry. If there are errors in the evidence that we've tried to summarise fairly, they will be identified by the inquiry, as well as, no doubt, by the oral submissions of other core participants. And of course, sir, we have already alerted the Deputy Solicitor of the inquiry of any factual errors that we've found to date, and we'll make sure that we participate in the process to do so, to continue to do so, that Counsel to the inquiry has now outlined to core participants. We respectfully repeat, sir, that the submissions were drafted with the object of assisting the inquiry, and bearing also in mind that the perspectives of some of those involved can't be articulated directly. It's for the inquiry to make up its own mind about whether we've succeeded in our objective of assisting it. So if I could turn to the second limb of what was said yesterday, the subject of financial compensation. This was about good faith and the position of the department related to financial support and compensation for the infected and affected. As everybody in this room will know, the government commissioned Sir Robert Francis to examine a possible compensation framework in an attempt to ensure that it had considered this issue, including the mechanisms for the delivery of compensation, before any report was published, rather than waiting for a report, as perhaps it might have done. Thereafter, linked to Sir Robert's work, the Chair's interim recommendation that interim payments should be made to those registered with the existing financial support schemes was promptly accepted by government. The recommendation was made by you, sir, at the end of July of 2022, and on the 16th of August, the Minister for the Cabinet Office and Her Majesty's Paymaster General, Mr. Michael Ellis, wrote to you, sir, agreeing that payments of £100,000 would be made across the United Kingdom to all beneficiaries registered with the national support schemes. The payments would be tax-free and disregarded for benefits purposes. Payments were made to eligible beneficiaries of the United Kingdom infected blood support schemes, and by the end of October 2022, around £400 million had been paid out. In relation to the issue of compensation, as the Paymaster General and Minister for the Cabinet Office, the Right Honourable Mr Jeremy Quinn MP set out in a statement to the House of Commons on the 15th of December, work is ongoing to consider the wide range of factors set out in Sir Robert Francis's study. A cross-government working group coordinated by the Cabinet Office is taking forward work strands informed by Sir Robert's recommendation. The work will ensure that the government is prepared to act swiftly in response to your final recommendations related to compensation. And the Department of Health and Social Care will play any part requested in this work, but it is being led by the Cabinet Office and coordinated across government and the 4 nations. Now, we recognise that amongst the submissions that the inquiry has received are criticisms of the fact that the government has not published a response to Sir Robert's work or moved more swiftly. The Cabinet Office leads on this work. The major response from government came in the acceptance of the recommendations for interim payments and in carrying out the work that was needed to implement that recommendation. We understand that Sir Robert made his recommendation in recognition of the fact that it would take time to consider and then to set up any system of compensation, just as the Chair, you, Sir, recognise that it will take time to complete this work. The submissions the inquiry has now had include requests from members of the community of the infected and affected for further consideration of elements of Sir Robert's recommendations to be made by the inquiry to widen them. This is not a simple process, and the work streams set up reflect this, but the government is committed to the process that it has outlined. The financial payments and commitments that have been made to date are, we suggest, or represent tangible proof of the acceptance made publicly on a number of occasions that the government owes a moral responsibility to those who are harmed through the receipt of infected NHS blood and blood products, prescribed or given to them by NHS doctors, nurses or other clinicians, and which prove to be infected by AIDS or hepatitis C. Apologies have been given on several occasions over the years, and most recently, on the 15th of December, the Minister for the Cabinet Office confirmed the government's acceptance again of Sir Robert's view that there is a moral case for compensation to be made. And before that, there was, of course, work done to deliver parity in the financial payments given across the 4 nations in 2021 in response to observations from the inquiry on this issue. Now, we had hoped that those efforts, together with the further ongoing work, represented visible and tangible evidence going beyond mere words of the sincerity of those apologies and of the desire to do what can be done to give some real and practical assistance and redress to those who've suffered. It may be that the submissions heard yesterday suggest that these efforts, including the acceptance of moral responsibility and the payment of interim compensation, have done little to mitigate the damage caused by suffering over the years. But we can only repeat that our client, the Department of Health, will continue to work closely with the Cabinet Office, which, as I say, leads on this work, not least because of that history, in the weeks to come. So if I turn then to the topic of any further submissions today, I would say that we had originally been minded to summarise what we regarded as the more central evidence in our written submissions today, as a guide to those who hadn't wished to spend time on them for understandable reasons. We'd intended to draw the threads together of what had been said in our written submissions. The primary aim had been to highlight aspects of those written submissions rather than to comment on the contents of written submissions made by other core participants, although we did have a few comments on some observations that had been made. However, in the light of yesterday's submissions, we don't propose to do that. We don't wish to provoke further suggestions that what we say represents a less than genuine attempt to assist the inquiry, or to stir up further comments to the effect that the department is putting its own point of view when the government should have listened more and read more, as we heard from some of the observations in the written submissions from the core participants. We do hope that the written submissions that have already been filed are genuinely helpful to the inquiry, which may make what use it sees fit of them. Instead, I'm going to make a few short remarks, if I may, about recent disclosures and the process of the inquiry over the last few years. I do regret any inconvenience caused by the delivery of a substantially shorter address than originally timetabled. In relation to documents that have been produced since the written submissions were filed, we note that counsel to the inquiry have produced a very helpful note on the topic of parliamentary privilege, and we welcome this. We would respectfully suggest that the Chair should provide a ruling on this topic after inviting submissions from interested parties, which might usefully include the parliamentary authorities. The point is of some constitutional significance, and without a ruling, the position which the inquiry has reached on the law will be clarified only once the report is published. I'll turn then, if I may, just to make a few concluding remarks, because we'd like to end by recognising again the importance of this inquiry's careful work. We'd wish to thank all of those who've contributed to its work, not only the inquiry's legal team, but the inquiry's staff, who have been utterly essential to its smooth running and have given so much help to all those who've entered this building. This includes support to all of those who've been following the inquiry's proceedings, as well as to the witnesses and the legal teams. In relation to those who've been following the inquiry, we would like to pay particular tribute to those who've been listening to the evidence in this hearing room, often day in, day out. The dignity of those who've been able to listen with such care and attention, often to what must have been difficult, sometimes distressing evidence, has been remarkable. We'd wish to place on record our thanks for the courtesy that has been shown to witnesses. Everyone present here, observing and listening, as well as the inquiry and staff, have enabled an atmosphere in which witnesses were able to come to this inquiry and be questioned in a courteous but rigorous manner. That this has happened is not only an achievement on the part of the inquiry team, which we acknowledge, but also an achievement on the part of those listening to the evidence. And we'd like to record our recognition of this and our thanks. We don't forget the invisible contribution of those who watched remotely. We're sure that they too were feeding into the proceedings. We're very glad that the use of technology has enabled wider participation, not least against the background of the COVID pandemic, which this inquiry has successfully navigated with care and thought, particularly with regards to the vulnerabilities of some of those who've been attending. Again, we'd like to acknowledge this. We'd also like to acknowledge the contribution of the many witnesses who've given much time and thought to their evidence. Of course, it's to be fully expected that serving civil servants and ministers will do this. However, many of the departmental witnesses were long since retired, but diligently sought to assist the inquiry, notwithstanding the challenges presented by age, infirmity, or just the passage of time. Now, I've just mentioned the departmental witnesses, but both they and the Department of Health itself would immediately continue by saying that we are all conscious, above all, of the contributions of the infected and affected who gave evidence. We recognise the strains imposed on them, not only because of the result of the challenges presented by age, infirmity, or the passage of time, as I've just mentioned, but because they were also being asked to revisit trauma and suffering. All of us who've sat and listened to their evidence will have memories of dignity, courage, and endurance, and will have heard evidence that was deeply moving. I'd like, on behalf of the department, to recognise their contribution both to the inquiry and to the improvements in policy and practice that we fully anticipate will follow the inquiry. And in that spirit, the department will now await the inquiry report and is committed to considering all of its findings and recommendations with great care. So that's all I wish to say.
Let me start by thanking you for your, in particular, the remarks with which you concluded, which involved the way in which all who have attended have respected the right of people to express their own different views. And to this day, that has been a hallmark of this inquiry and the dignity and restraint with which many have watched the proceedings. My own position, let me make it clear, I do, of course, intend to reach my own conclusions on all the evidence which I've heard, exactly as you said, and I understand the position of the department in not wishing to preempt anything I might say or indicate a contrary view. I have been particularly helped by many of the much of the material which the department has provided in general. I say in general because there have been the odd wrinkle, as you well understand, that the department has done its best to help and provide material and information and to support the witnesses whom it felt it could support. In that respect, although I understand that the department's position is not to take a position, it does strike me that when the inquiry opened, you did, on behalf of the department, appear, at least to me, and no doubt to others, to take a position, and that was that wrong had been done. It would help me, without in any sense prejudging any of the other findings I might make, to understand what wrong the department had in mind when you said that.
Well, sir, that's an invitation that you extend to me. We have been careful, as I've said throughout the submissions I've made and in the written submissions, to say that we don't have a position to offer to you on what that might be. Now, if the inquiry wishes to press us further on that, I can take that back to my clients and we can reflect further on it. But it is our position, as I've just been explaining to you, that we think it's fairer not to do so and not to seek to preempt the position, the conclusions that you will reach.
It might occur to some that apologising for some wrong that has been done without knowing what the wrong was, at least at that stage, I appreciate that views on whether it was wrong, whether it wasn't, may have changed over time. And after all, when the inquiry began, it was open to me to find that absolutely nothing wrong had happened at all. But you were there saying, no, wrong has been done. What exactly can you help? Was it at that time, as a matter of history as opposed to now, what was it that the department had in mind that you were apologising for?
Well, sir, I can't answer here and now as to what happened or what was thought by those in September 2018. If you wish to press me further, I'll go away, take instructions, seek to respond. But I'm not able to give you an answer now in this inquiry hearing chamber.
Well, I note your response. Thank you. As to the other matter you mentioned, the question of privilege, we shall give it due consideration. I think counsel to the inquiry left it open to those who wish to make submissions about that to do so in the course of these submissions. But it may be that it's appropriate to have them at a later stage. I shall reflect on that. Thank you.
Thank you, sir. Thank you all.
Sir, our next speaker is scheduled for 3:30, and I'm asked to say, could we stick with that time and therefore have a slightly longer break now, please?
Yes, we'll do that. 3:30, a longer break.